Let's begin here. The deadline for parties to address the differences over the sections 4 and 5 of the BELA Act, of course, looms. While President Cyril Ramaphosa signed the bill into law, the two sections were left out amid some concerns, and then there was a process to then see how these issues can be resolved. We speak now to Basil Manuel, who's the Executive Director of another teachers union, NAPTOSA, the National Professional Teachers Organization of South Africa, and joins us via Teams. Basil, thank you so much for your time this evening. There are mixed views on whether or not the president should have delayed the implementation of this act in totality and simply leave out sections 4 and 5. Others are saying that he should have. Others are saying that he should not have opened this process for consultation. What does your union say?
Well, in fact, I suppose it is very difficult to get a common view. We have, after the fact, looked at it, and we did agree that it was a great pity that we didn't implement immediately, because in fact when you look at what the solutions today are about how to continue after the palaver with clauses 4 and 5, you would see that it's exactly where it would have gone had it simply been implemented. So yes, we believe the 3 months was a waste of time.
Let's look at the sections themselves, because some people do forget. Others are simply not aware of what we're talking about. If you can bring up section 4, and then we'll look at what clause 4 then says of this particular act, in order to be able then to see what exactly does clause 4 then say, and we discuss it in greater detail in order for us to then be able to discuss it. I'm not sure if we do have clause 4 and we can then be able to bring it and just look at its implications and what does it mean then for the school governing bodies. And I just want to check with the team if we do have clause 4, if we can bring up clause 4 now so that we can then have this discussion. All right, Basil, it does seem like we do have a challenge there, but eventually we do have it. Clause 4 says that the governing body needs to submit the language policy of a public school and any amendment thereof to the head of department for approval. Some, of course, have been looking at this to say that the powers may not be delegated completely. Let's talk about your position as a union on this clause 4.
I think it is pretty simple. Schools have never been a law unto themselves from the beginning of time, and neither are they now. There's always been a higher authority, and rules at a school, whether it was for a specific purpose, just one day, whether it was admissions, whatever, there was always a higher authority. So we believe deferring to the head of department is not something new. Our view and our guidance to our principles has been stick within the framework of the law, stick within what the Constitution allows, and you won't run foul of what a head of department may demand. It cannot be unreasonable. This is an issue of access. And because it's an issue of access, we have felt particularly strong about getting it on the statutes and running with it.
And I remember at some point, just before it was signed into law, there were concerns, though, from some who were saying that if you are to then defer to the head of department, you may find that you're inundating this particular individual with so much work that there may be delays in the implementations. And when we spoke to the Department of Education, they said, no, there are not going to be any delays. They do have a group of people who will be able to look at this particular issue. What is your sense there?
Well, that was our main concern, was not where the authority lies, but whether there is capacity to do what the Act is saying will be done. And it remains our concern, because what we don't want to see is that issues are delayed for so long that a default starts kicking in. And I'm happy to hear that people who are schooled in the particular Act, and in particularly is schooled in the Constitution, will be on hand to assist and advise the head of department. And that satisfies us. But of course, it has to be tested. We don't want undue delays. That will simply just feed into a view which says that the department doesn't have the capacity.
And when we look then at Clause 5, if we can bring up Clause 5 and then just have a discussion around it, because it was also one of those clauses that also then popped up when it comes to, some of the contention here. And it says that it empowers the minister to appoint outside agencies or persons to advise the minister on matters relating to a national curriculum statement and national process and procedures for the assessment of learner achievement. Your union's take on this?
Mine is a simple question. What do people think happens now? What do they think happened before the BELA? And in fact, this has been the norm, that the minister herself is not an expert in curriculum matters or assessment matters. Neither is the head of department. The unions are involved, parent organizations are involved, university professors, etc. are involved, and that has been the pattern of things. It is not assumed that a person is a complete expert. They have to have people to advise them. And it is in that advisory role that we get the best model. That is what currently happens. So this is no big change to what currently happens. This is what we would call a straw dog. It is diverting our attention away from the real issues.
So if then this is what had was happening to begin with, why then the contention?
The contention is sometimes about other things. When it comes to the language policy, it was that people made it about a language, and they forgot that schools don't have a language. The community has a language, and the school adopts the language of the communities. And communities are changing, so there have to be changes. It is foolhardy to think that a school, because it was once upon a time an English medium school, will remain like that. And similarly, in terms of many, many other clauses, what has been decided insofar as our knowledge is concerned is that there are still many rules, regulations outstanding or directions outstanding for a number of clauses, including, for example, grade R. And these will be refined, and they will refine how we act or give life to these particular clauses. So we hope that that calms people down. And this whole issue of trying to make it about a language dies, because languages are about the people. And that's the bottom line.
It sounds like the department may be in a catch-22 situation here. And I ask this because there are some who are saying that if you implement it, then we're going to court. And others are saying if you don't implement it in full, we're then also going to go to court. How then do they begin to resolve this one?
Well, unfortunately, we have become a very litigious society. And I have no doubt that some people will approach the courts. But I cannot see, and our legal people have told us that there is nothing unconstitutional in the BELA. And we are waiting to be schooled differently and see whether it is like that. Insofar as the other side is concerned, I can see that people are tired when it comes to issues of access, that there seems to be deferring of access all the time. Now, the BELA has struck a golden chord. There are many clauses that have to do with access. It's not only language, and it's not only admissions policy. It's about pregnancy, it's about grade R, it's about the compulsory nature of schooling. And these are things to be embraced in their totality.
So if then there are all these issues, around the differences and the fact that you cannot seem to find common ground when it comes to some of these particular sections, especially Section 4 and 5, there are some experts who are saying that the Act could take 2 to 3 years in order to be finalized and be phased in properly when it comes to the schools. So how much of a delay is it then if you do have these disagreements and then you need to implement this as speedily as possible, and we're hearing that it could take up to years then?
In fact, I agree with the experts, and I agree with the view that is said that to fully implement the Act will take some time because of the very rules and regulations that I've spoken about a few minutes ago. So this does give us time to convince one another and to allay fears that have been spurred also by a lot of people who have made political mileage out of this. And I believe that is where the solution lies. Delaying any clause any further is of no value, because at any rate, it will take some time to fully implement all the clauses.
So listening to you, it sounds like you're saying that in fact, the delay is more of politics than it is about the education sector itself.
I firmly believe that from where I'm sitting, and my union firmly believes that. When we've looked at this coldly, like so many people have done, and we've looked at how much input we've made over a 10-year period, we are saying we can live with what is there. Is it perfect? Is it ever perfect? Should be the question. No, it wouldn't be. But can we live with it? And that is what we're saying, we can live with it. So we are saying implement it. Let's get on with the task of creating those regulations where they are needed. And hopefully this contributes to improving our schools and access to many people who have been excluded.
And access is a huge issue. Thank you so much, Basil, for your time. I appreciate it. That was Basil Manuel, who's the Executive Director of the Teachers Union, NAPTOSA, the National Professional Teachers Organization of South Africa.